What are the basics of the Brown Act? Number one, all meetings have to be open and public. There's a little exception to this. It's actually a big exception that I'll talk about in a sec. But for the most part, the meetings of any decision-making body must be open. That means they do it within the jurisdiction where that agency resides. It means they have to tell you when they're going to meet, usually 72 hours ahead of time. And it means you get to attend without showing your ID card, without having to sign in and say you're not a communist or a socialist, or paying a fee. Okay? You get to go watch them do what they do. You have the right to record the proceedings. Now normally, California has a rule that says you can't turn your recorder on if people don't consent to it. Right? That's generally illegal. But when you go to a public meeting, you get to have the cameras, you get to turn on your iPhone and record what they say, as long as you're not disrupting, perfectly legitimate to record it. The other thing you're entitled to know is what they're going to do at the meeting. It's not enough to know they're going to have a meeting. You actually get to be told in advance what they're going to do so that you can come prepared to participate. This is called the agenda posting requirement, and at least 72 consecutive hours before the meeting, they've got to tell you what they're going to do. This is kind of a biggie because it used to be they were just required to post it outside City Hall or outside the school administration building, and you'd have to drive down there and check it out. But the rules now say that the highest body, City Council, School Board, Board of Supervisors, they have to post and publish on the internet. If you read an agenda, it'll say item 1, item 2, item 3. You're not entitled to see the backup materials 72 hours ahead of time. That's not the rule. The rule is, when the materials go out to the public officials, then you're entitled to see them. So some agencies put them out ahead of time. Some of them don't turn them over until the last minute. It depends on your agency. But you at least get to see them once the public officials get to see them. Another thing about this backup material rule is that you also get to see what anybody gives them at the meeting. So, during a meeting, if you see somebody walk up and hand them a stack of papers, if it's a private person, you get to say, I want to see what that person just gave you. And promptly after the meeting, they have to give you a copy or make it available on the website. When it's the agency staff that's giving stuff to the decision makers, you get it right now. Okay? Everybody get the difference? Joe Blow walks up and says, I want you to read this. You're entitled to say, can I see that after the meeting? City attorney walks up and says, I want you to see this. You get to stand up and say, I want to see it too. That's the rule. Basically, if there's a body of people making a decision and it's been set up as an official body, you get to watch and you get to look at their agendas ahead of time and you get to go and participate. Another important point, a majority, you can't have a majority of the body deciding things behind closed doors. We have an example of that here in Chula Vista right now, and Marco and I and Chris and Sandog have filed a lawsuit over it. Because there you had members of the city council voting on who wasn't going to be considered for an appointment, and they were doing it privately, on their own. That's a no-no. Under the Brown Act, you have to meet publicly, and you have to hold your deliberations publicly, and you have to gather your information publicly. On an agenda, there are two ways that you can talk as a member of the public. One way is what's called non-agenda public comment. At every meeting, you're entitled to get up and talk about anything you want that is in any way relevant to the agency. You can get up and you can call people communists. You can get up and tell them you think taxes are too high. You can get up and ask them to adopt a resolution telling Congress to fix gridlock in Washington. All of those things are fair game as long as it's within the jurisdiction of the agency. You can even get up there and complain about the chargers if you thought there was some connection to that agency. All of that's fair game. And that's called non-agenda public comment. The other way you get to participate is on every agenda item. When they go through the agenda and they say item number 1, if you want to speak, sometimes they'll have you fill out a speaker slip. Other times they'll say raise your hand and come forward. You get to speak on that item. Okay? Non-agenda public comment, anything you want, as long as the agency has jurisdiction over it. They won't take action on it that night, but you can talk about it. And then the other one is whatever they're considering, you get to talk on that item. The agencies can adopt rules for the orderly conduct of the meeting. And one of the ways they do that is they say fill out a speaker slip. If they have a formal rule that you have to fill out a speaker slip, you got to fill out a speaker slip. Now sometimes people get there late. Sometimes we've had problems where you don't think it's going to be controversial, and then you hear the staff make a presentation and you realize, oops, this is a no-no. And you go run to fill out the slip and you turn it in, they say, nope, you're supposed to fill out the slip before staff makes a presentation. That's all bogus, by the way. But it's just a way of shutting you down. So you just stand there and you make the stink. And most folks are smart enough, they'll say, okay, here's your 2 minutes. And they'll sometimes say, tell us your name and address for the record. You don't have to do any of that stuff. You already filled out the form. You're not required to give your address. You're not required to give your name. You can't do any of that. The deal with closed session is that you are entitled to address the body before they go into closed session. So on the agenda, it will tell you the time when they're going into closed session, maybe an hour or 2 before the regular meeting, and they will convene in open. They will say, does anybody want to talk on closed session? If you do, you go up and you say your piece, and then they go into closed session.
First question we have to ask ourselves, who's subject to the Public Records Act? We all kind of get it at state and local governments and the special districts like water districts, sewer districts. But it's also the committees that are created by these public agencies, including those that are just advisory committees. And then there are certain private nonprofits, as long as they are given some sort of legal authority and public funds to carry out their public functions, their dealings are also subject to the Public Records Act. But what is a public record? It's any writing. Makes sense. But it has to contain information relating to the public's business, prepared, used, retained in the course of business, and again, regardless of the form or the actual characteristics of it. So first looking at what is any writing. The Act says that it can be in print or electronic form. In fact, it can be in handwriting, it can be typewritten. In a modern day of electronic mail, it encompasses all manners of communication that might occur. It can be dictation, it can be traditional email, it can be faxes. But any writing, regardless of the manner in which it has been stored, is subject to the Act. And then what is information relating to the conduct of the public's business? Just because an agency holds onto a record doesn't necessarily make it a public record. But if the record is kept because it is necessary or convenient to the discharge of official duties, then it becomes a public record. Most things in the files are a public record. The Act does not apply to records that don't exist. That sounds like a nutty thing to say, it's fairly common sense. But the reality is there are people constantly going in agencies and asking for things that that they don't have or that another agency has, and people have to realize if you don't go to the right agency to ask for the right document, they can simply say no. There's no duty to create records in response to a request, and that's also important because I think sometimes people go forward and say, can you make me a spreadsheet of all of these documents that might exist out there? If it requires the city or the agency to actually create a document, then it may not be subject to the Act. But you should know it. If you go to an agency and you say, I want this document, they can't simply say, sorry, you didn't ask me the right way, or no, I think that might be too hard. They actually have a duty under the Act to assist you to narrow down your response, to tell you how you might better frame your request, and basically suggest how you might overcome some of the legal hurdles that the Act creates, or that the agency might have in its own statutes to keep you from getting those records. And so it's nice to know when you ask for something and they say no, that you say, well, help me, how do I get it? How do I better describe it? Who has access? Everybody has access. Everybody is supposed to be treated the same. I know in the media they submit probably more public records than any activists out there, but they're no more entitled to it than you or me or anyone living down the street. It doesn't matter if the person requesting documents has bad motives. If you go and you want to get documents because you think your neighbor is a jerk, you still get to get those documents. If you're a litigator, like me and Cory, and you want to go get public documents you can tell them, hey, this is because I want to build a case against you, clerk standing there at the desk, and they still have to get you those documents. There are exceptions. The district attorneys and people who are requesting information about themselves, they are entitled to a little bit more documentation, but that's kind of common sense too. How do you make a request? Guess what? There is no required format. You will go into cities all up and down in this county, and they will say, oh, you want to request a document? Here, fill out this form. You know what I like to do? I'd say, you fill out the form. I'll tell you what I want. If you want to keep a record of my request, and I'm standing at your counter during business hours, I'm going to tell you what I want, and you can write it down, you can put it in your file. I'm not writing it, I'm not signing it, I'm not telling you my name, and I'm not telling you why I want it. And if they have a problem, ask them to go get county counsel or city attorney. Case law is very clear. You don't have to make your request in writing. You can make it orally, and you don't have to give your identity or affiliation. You have to request something that actually exists out there, and they've got to be identifiable. You can't give this nebulous notion of well, I want anything that might possibly relate to the tax rolls on, short people who, were born in the 70s. You have to actually ask for documents that exist. And there's an important distinction between requesting information and requesting documents. Under the Public Records Act, if you go up there and you say, I want to know this issue, I want you to answer this question, they can look at you and shrug their shoulders and say, I don't know, go figure it out yourself. But if you go up there and you say, I'd like all documents reflecting electronic communications between that planner and that traffic engineer, as long as it's not exempt, they have to turn it over to you. Does the agency have to provide a means for you? I've never seen that issue come up. Most cities have a counter. So a planning counter, an engineering counter, a clerk's counter. You can go to a clerk's counter and say, I'd like to see this document. Now, it's important, if you make that request during business hours, and that's a readily available document, they have to go and get it right then. They can't simply say, put it in writing, we'll deal with it later. That's a very important thing that a lot of people don't understand about the act. They have to go and help you then. They can't simply say, I'm busy, it's too hard, I don't want to. As long as it's a reasonable request and it's readily available, they have to go and do it. We go in, the media goes in, and we say, I want certain records that are really voluminous. I want 10 years worth of data. And the question is, do they have to go and compile all that? And if they can be produced with reasonable effort, oftentimes they're held in electronic format or they're relatively easy to find in a file cabinet somewhere, then regardless of what it costs the agency to compile them, they actually have to produce them. If it is unduly burdensome, now these are squishy terms, and they oftentimes make this claim, if it's unduly burdensome in light of the value of the records, an exception may apply, but the burden is on the agency to explain to you how the records are kept, why it's unduly burdensome, why they believe that they should qualify for one of the exemptions under the Act. Can the agency condition disclosure on the requester's use? An agency cannot demand to know what you intend to use it for. I've had them ask me dozens of times, why do you want it? I say, none yet. Sometimes they say, what do you mean? I say, none your business. Okay, so even if you're going to use it for commercial purposes, believe it or not, being a municipal lawyer, a lawyer who deals with agencies, in my firm, we have 13 attorneys who do a lot of business work, and knowing this act has proven phenomenally helpful in doing business. When a commercial entity comes to us and they want to do stuff, and then sometimes even on the personal injury front, knowing that we can go to the government and get these records is really helpful. One of the things to remember, though, is that you can't ask for something that requires an entity to create new documents. Sometimes the agency recognizes that they do better by creating a new document for you as opposed to giving you stuff that's all kind of all over the place. They'll create indices or cover pages or things like that. But by and large, if you go in and you say, I want to know all of the slip and fall cases you've had on this street corner in the last 20 years, they might be able to provide you 20 files, but they're not going to be able to create a document that kind of summarizes all of that for you. If you submit a request, either in writing or orally, and they don't intend to provide the documents, the denial has to be in writing. It's got to cite very specifically any exemptions that they rely upon for the denial. And importantly, it must include the name and title of the official responsible for denying access. When I remind this to officials, it makes them nervous because it means their name's going on the top of the complaint when we don't get the document. So how should agencies respond? This is how we hope they would respond in every circumstance, but we don't always get it. They either say, there's no responsive records. We couldn't find anything that matches your request. Or they say, we're going to produce the responsive records, but we'll have them tomorrow, we'll have them in a week, or we're going to hold them back and we're going to claim some exemptions. Where things get dicey is when city officials talk to other city officials and copy the city attorney's office. Because then it becomes this question of, is this an attorney-client communication? Is this part of a litigation or a pre-litigation communication? It gets even more difficult when you have outside counsel and you've got city staff, talking to an attorney who's outside of the city who may or may not already be hired to represent them, and whether an attorney-client relationship exists. But in the general sense, if you are a city official, whether you're elected or you're an employee, and you're communicating with someone outside of the agency, those are all publicly discoverable documents, even without litigation. So, look, the case came down, the San Jose case, pretty much defined it. There's still chances that the U.S. or the California Supreme Court's going to do stuff with this issue, but the general consensus is if you're using your private email for public business, that is a public record. Just as with the Brown Act and with public comment, agencies can adopt certain procedures and different things that might affect how you come in to get documents, especially if it's going to help you get them quicker. When it comes to inspection or copying, they have to be made available during business hours. The agency can put specific, like babysitter type of practices into play where they make sure that you're not going to damage them or steal them. I've had inspections that have lasted 5 hours a day for 10 days in a row. And some unfortunate staff member has to sit in there and watch me go through boxes and boxes of documents. If you are told, come on in, you get to look at this record, and you don't say, I want to copy it, they can't charge you. It's very important to know that. When I write my request, I think Cory does this too, we oftentimes say, before you do anything that's going to result in a charge, I want to be notified. And that way you can kind of gauge. Sometimes they try to ding you with, research costs or something like that they're not allowed to. And I always say, I'm going to come in and inspect it, I will tag it, and I will let you know if I want it. And by the way, if it's available electronically, you should probably just send it to me right now. They can charge you for the cost of running the copying machine. They can charge you for the time it takes for a staff member to stand at the copying machine and press the button, and they can charge you for the materials, the paper and the CDs. It does not include the staff time associated with going to the file cabinet and finding it, going to the basement, going to the microfiche and retrieving it. You can't get charged for that staff time, only the time they spend standing at the copy machine. And the fee must reflect the actual cost. Most agencies will have a regulation that says you need a bonded copying service to come in, and it's simply because they can't have you destroying documents. You screw up, you don't have insurance, you're not bonded to replace it, to deal with what might be a very important document.
So you can still photograph it.
Photographing, it's a great opportunity. The cost to copy e-records, they can charge you for the disk, and I can't tell you how annoying it is in this day of Dropbox and email that people still sometimes say, sorry, you got to pay $15 for a diskette. And guess what? You can't bring in your own sealed, recently purchased 39-cent equivalent diskette. They just use it as a way to keep you from getting documents. You don't have to pay for compilation, extraction, or programming. You only have to pay the copy to produce it. The most common exemptions we see are preliminary drafts, notes, and memoranda, pending litigation records, personnel info, privilege and confidential info, and the public interest balancing test. Real quick, preliminary drafts, the basic notion is that, hey, these aren't kept in the ordinary course of business. We look at them, we use them, and then we discard them. If preliminary drafts are kept, they can actually become business records, and we've won cases on that issue. But again, if it's the agency's policy to take versions of early drafts and get rid of them, then they're not. And again, you have to do this public interest balancing test on them. The most important thing to remember about pending litigation privilege is that when the litigation is over, the privilege is over. And this also applies to investigative type privileges. So let's say there's a code enforcement investigation going on. The code enforcement officer in that division is pretty much like a prosecutor. They're trying to gather evidence, they're trying to build a case. That stuff is all privileged. But after they choose not to prosecute, close the file for any reason, prosecute and win, prosecute and lose, you can circle back around and require them to open up those files. The exemption goes away once the litigation is done. There are no such things as public entity confidential settlement agreements. That's an important one to sink in. A lot of times as private business lawyers, We have companies that do not want the public to have access to the terms of a settlement. But when the government settles, whether it's with us or, you know, some other agency, that settlement agreement needs to be made available, and they are typically disclosed out of closed session after or under the Brown Act. When you have personnel who are being disciplined, or you have information in a personnel file that is private, you know, when you're talking about reviews, a lot of times those types of things are going to be privileged, but not all the time. Just because it exists in a personnel file doesn't mean that it's not a public record. You have to have a little bit more in-depth analysis to determine what specific things are able to be withheld. But as you can imagine, things like medical files and things that might otherwise end up in a personnel file do not get disclosed. The deliberative process exemption, this one is very interesting because this was at issue right here in Chula Vista on the case that Cory was mentioning, where we're challenging the city for essentially having a secret ballot nomination process prior to the open process of selecting a replacement for Councilmember Salas when she became the mayor. The city council members put together a list, and each of them sent that list to the city clerk. The city clerk looked at that list and basically picked any name that at least 2 people had nominated and put that on a separate list that would then go out to the open. Well, that whole process, those documents that were sent by the council members to the clerk with their original nomination, they tried to claim were deliberative process privilege. The idea being, hey, if we have to disclose to the public how we deliberate and reach our decisions, it's going to chill the way that we make decisions. Sorry. You don't get to be a Democrat sitting on that council nominating a whole bunch of Republicans without me finding out about it. That's just not how it works. At the end of the day, if you are going to transmit a document from the city council member to the clerk, that is a public document, and we will beat this process every time, this deliberative process exemption every time. And they, of course, recognize that because when we threatened to sue them on that specific aspect, they pretty much immediately turned over those documents.